Welcome to Privacy Abbreviated, brought to you by BBB National Programs. As our regular listeners know, our goal here is to help business leaders prepare and operationalize for what's next in the privacy space. I am Dona Fraser, Senior Vice President of Privacy Initiatives at BBB National Programs. And today I'm joined by two very special guests as we discuss the COPPA rule, proposed changes, the impact on industry, and at the end, we'll have kind of a magic 8-ball prediction for you. My first guest is Sara Kloek, who is the Software and Information Industry Association's, or SIIA, Vice President of Education and Children's Policy, focusing on a broad range of issues, including student and children's privacy. Sara and I go way back to when she was working at the App Association and I was working at another COPPA Safe Harbor provider. We've been in this space with each other for a long time, in the trenches, as I would say, for a very long time on COPPA. My second guest is Rukiya Bonner, who is our Director of CARU, the Children's Advertising Review Unit, which operates our COPPA Safe Harbor. Rukiya has been with us for almost a year now. She came to us from Discovery and is very much in tune with what companies need to do in order to really engender trust amongst their consumers and amongst their users. So I think between Sara and Rukiya today, we're going to have a great discussion about COPPA, the COPPA rule, and what's next for you all. Let's just jump right in. Sara, I'm going to start with you. We had the FTC finally, after 5 years, publish the proposed changes to the COPPA rule, right? So they had originally asked for comments back in 2019, and they decided to put some coal in our Christmas stockings and release something in December of last year. And we have all been pontificating on it, and I believe the comments are due March 11th. So where are we now with the COPPA rule, with COPPA? How did we get here to where we are now with the COPPA rule?
Sure. Let me take a step back and give a little bit on COPPA. It's a law that intends to protect the privacy and security of information collected online from known children. I think the piece that Commissioner Bedoya put out with the Christmas coal in our stocking on December 20th was really enlightening and gave some really good legislative history of COPPA, including about how it first took off in the Senate, about how a pen pal website released kid contact information without notifying and getting permission from parents. So something which seems so simple and so weird to have a website do was the basis of the law. And Commissioner Bedoya also wrote that the harms that COPPA sought to prevent remain real, and COPPA remains relevant and profoundly important, which I think is important to consider for this podcast. The FTC last amended the rule in 2013 and did a number of things in that rulemaking. They modified the definition of operator. They introduced the concept of mixed audience. They expanded the definition of personal information, strengthened data security requirements. And then we had some years where we were all complying with the 2013 rule. A number of groups issued a YouTube complaint in April of 2018. There was a case against YouTube in July of 2019, and the rule review also started. The FTC announced a rule review in July of 2019. Then 2020 happened. So I think there was maybe a little bit of delay that happened due to 2020. And then we saw a flurry of action in 2023. The FTC announced a case against Edmodo. And then in December of 2023, they announced a rulemaking. So it took some time, but also we had the start of a global pandemic in there. So I'm going to give a little grace to our friends at the Federal Trade Commission. They also received tens of thousands of comments in response to the rule review they started in 2019.
Let's go back, though, to 2019, because my recollection is that they actually fast-tracked what was the original schedule to review the rule, right? Because they felt like technology is moving at such a rapid pace, and that they couldn't wait. I think it's clear that the FTC recognizes that as nimble as the law may be, the rule does need to be updated. The law is written quite broadly, but the rule is what people refer to. That is what's giving guidance to industry about what to do and how to do it. So I think it was necessary to do that. And since then, we've seen movement on a federal level. We've seen great movement in the states. So I think it's clear that everyone have children on their mind. And I think what we've also seen is the expansion of the definition of children. The COPPA rule obviously does not address that, in part because legally it cannot. In order to change the age, that has to, the actual law has to be amended. And we're not hearing, well, we are hearing things about amending COPPA 2.0 or CTOPPA. And we could talk a little bit about that. Let's talk about the rule. Let's start with talking about the rule and what it means and whether or not companies need to. I don't think they need to do anything today. Nothing's changing tomorrow. But what should companies be looking at? Where should they start being proactive?
One of the things that I know the proposed change would require companies to do, and probably it would look like an additional provision in their privacy policies, the proposed change would require companies to identify and disclose the practices for which they're collecting the persistent identifier and the means that they're using to collect the persistent identifier. And that's, including through targeted advertisings or prompting a child to engage, encouraging a child to use the company's services. So that's one thing that companies would likely have to put an additional provision in their privacy policies.
Yeah, I also think that a lot of the things that have been included in this rulemaking are reflective of some of the trends that we've been seeing in some of the FTC cases against companies, and also trends that we're seeing from even best practices that companies are doing. So I think that reading this through carefully about what your company may be able to do to protect children. The FTC is really clear about their expectations of where they think things should go or where they hope things can go. They did take great care to spend, 164 pages talking about where stakeholders are, what they're thinking about. So you kind of get a really good view of where the broader community is thinking about how online operators should be protecting children, but also outlining what parents and kids are thinking about. So I think there's some really good, and I know this is a little pitch for a safe harbor, but the safe harbor programs can help you think about, in the interim, before we have a final rule, what's doable for your company, what seems like a really good practice to implement, whether it's data minimization or some of the security requirements. Can you incorporate those into your existing security program? And what would that look like? And can a safe harbor help you get to that path?
Before Rukiya talks a little bit about safe harbors, I do want to focus on that data security issue, because it seems as though that is one of the things that companies can begin to think about and should, regardless of where this final rule goes. There's something to be said for increasing your data security parameters and thinking about what you need to do. Because if it's not on, if it doesn't make the final rule and the FTC decides to not talk about, and I don't think that's going to happen. I actually think that they're going to, quite frankly, strengthen the data security practices. But if not the FTC, state AGs are asking this. The federal government is asking this. Outside the US, you're being asked to do this. So let's not wait for this to happen, right? I think it's one of those things that companies can actually and should be really thinking about doing and figuring out how to not just secure the data, but think about, again, what you said, Sarah, about data minimization. Do I actually need this data? What do I need versus what do I want? And what do you really need for a user to get from A to B? What is really required for that user to engage in your product? What's nice to have, and whatever it is that that's the nice to have, they need to figure out, well, how am I asking for that? And how am I notifying users about what I'm going to do with that data that I am collecting?
Donna, as you talk about things that companies need to think about, additional security means, data protection, and user engagement, thinking about some of the one of the things that the FTC proposed was new means of verifiable parental consent, otherwise known as VPC. And one of those means is through text messages. So parents would proposedly be sent a link, and that would have to be safe.
Oh, I think the FTC even talked about the problems with text messages in that there could be link spoofing or something like that that may cause some security risks with that method. But the way that we all are using our phones these days, making it so we don't have to call a 1-800 number and talk to somebody and do all of that, where instead we can just do click, 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 click. That's a lot more seamless and a lot lower barrier to entry, but also a meaningful consent process. But how do we make sure that data is secure?
And I think it's an opportunity for those companies who are already in the space of doing this for other industries to really think about how they can provide these services to those in the children's space. I think it could potentially be a really huge opportunity. Rukiya, I want to go back to, Sara mentioned safe harbors. So let's talk a little bit about CARU's COPPA safe harbor, and give the audience a little bit about what safe harbors do, what we do.
As we celebrate 50 years, in the mid-90s, CARU began to notice the intersection in protecting children from false and misleading ads. We began to notice the intersection of advertising and privacy, and as such drafted privacy guidelines. The FTC took CARU's privacy guidelines, and that was the framework for COPPA, what we now know as COPPA. So as such, CARU became the nation's first safe harbor program. Companies come to CARU or seek safe harbor status from a safe harbor program. There are other safe harbor programs. They really do it to demonstrate extraordinary care and ensure that they are compliant with COPPA regulations. And so the proposed changes to the Safe Harbor program, one of them requires that we publicly disclose a list of participants, as well as each approved service, the website, online product. And of course, CARU welcomes the transparency with the FTC about its business model, consumer complaints, disciplinary procedures, technological capabilities, but it would put other additional requirements on safe harbor programs. But people come to safe harbor programs to certify their products, to demonstrate safety and trust that that it is COPPA compliant in connection with the collection of children's information.
So I want to add a couple of things, and then I want to talk about something that may be a little bit controversial in one of those safe harbor requirement changes, but for those who are listening, to become a safe harbor, to become a FTC-approved COPPA safe harbor, there is an application process, which includes a public comment period to review the guidelines. So as it stands right now, I think now we're down to 5 COPPA safe harbors in the country, including us. There were 6. Point being is that they're few and far between of us. And there aren't a lot of companies collectively between all the safe harbors that are using safe harbors. There are many out there that should be using COPPA safe harbors. I would obviously encourage them to do so, because compliance with the rules actually very challenging. The more that you want to do, the more challenging it becomes to understand compliance with COPPA and how it intersects with other data privacy laws, both here and abroad. It's becoming more and more complex, especially for those companies who have a global presence. If you're compliant with COPPA and you have a global program, you're about 90% probably where you need to be. So one of the changes in the proposed rule is the public disclosure of companies that are participating in safe harbors. and I have to wonder, and I'll ask you both this, what your thoughts are, is that right now we do not do that. None of the safe harbors provide that list. Now, I've been in the safe harbor space for some time. We won't say how many years, but we used to do this. I wonder, though, if now going back to that, are we putting a target on the back of these companies from consumer advocates and other organizations who are then going to say, okay, we're going to double check your work and make sure that, yes, if you're with a safe harbor, that you actually are compliant. Are we unnecessarily putting a target on their backs?
Yeah, I think a lot of that is the intent of that. I believe the intent of the proposal for the transparency was to get at. There were some individuals and groups that were concerned about the safe harbor program. So I think there was some ideas raised that putting a list out there of companies that participate in a program, then the outside groups and people could evaluate these companies on their own. I do think, however, just like the majority of law firms don't list their clients and what they have on their what the companies or people are using the law firms for. I think there is some sort of ability to have those frank discussions with a COPPA safe harbor, or in my analogy, a law firm, about what you need to do to protect. And we aren't privy to the conversations or internal business decisions. So figuring out what a program looks like and what companies are doing and not doing to comply with a program. I think there may be other means for transparency, whether that's reporting from the safe harbors or audits or whatever. And I'm not calling for any of that. This is a discussion for the safe harbors. Where my organization, we're filing comments. I don't even know if we're going to talk about the safe harbor programs. But I do think that figuring out how to make this a strong program, the safe harbor program, a very strong program, is really important, because I do think that there is great value for companies and the broader movement to protect kids' privacy to have these safe harbor programs that the vast majority are establishing programs that have a higher bar than COPPA.
And the goal, the intention of a safe harbor really is for the FTC to say, okay, if you're a member of a safe harbor, we're going to presume that you are doing the right thing and that someone is ensuring that you're doing the right thing. And we're not going to come after you for violations of COPPA. We're going to go to your safe harbor if we find something or hear of something. We're knocking on the door or ringing the phone of your safe harbor to give them the opportunity to first correct whatever it is that they're seeing. That is, I think, one of the greatest values of safe harbor is this potential shield. There's no guarantee, but the potential shield of a phone call or a letter or an investigation from the FTC. Obviously, if it's egregious behavior, that's a whole other story. And honestly, for us, if we saw one of our safe harbors just not adhering to the compliance efforts and the guidelines, they would no longer be in the program. We have the ability to remove them. We will remove them, remove the seal, and it's a done deal. But I need listeners to also understand that there's a lot of work that goes into being a safe harbor and ensuring companies are compliant, right? We're looking at God knows how many mobile apps, websites, but we're also looking at the third parties. So, we could talk about the downstream of data and what that means. But looking at the third parties, because we know that everyone, and we saw this in the 2013 amended rule, third party liability, everyone who's touching that data is responsible for being compliant with COPPA. So it's not just the first party, it's everybody who's touching that data. So, and I think that this amendment to the rule just goes further reinforcing that.
No, I just agree 100% with the whole spirit of a safe harbor. And when you described potentially putting a target on companies who do due diligence, who take care, who want to demonstrate trust, we definitely wouldn't want to do that. And I can't imagine that would be in the spirit of what the FTC actually wants. A lot of the companies that come to us for safe harbor status, they will give us, CARU has a great relationship with the FTC. Just like you described, we're able to go present scenarios, kind of make sure that our companies are protected. So if there would be anything to potentially put our target on any of our safe harbors backs, I don't think that will be in the spirit. And I even think that's consistent, not with the safe harbor proposed changes, but I know one of the other proposed changes that the FTC talked about, companies who go through CARE to determine what their audience is. So I agree that we wouldn't want to do anything to put a target on any company's back that seeks safe harbor status.
Right. Yeah. And I think you touched on something with regards to knowing who your audience is. So let's shift a little bit, because I think that there is this ongoing conversation about what is a child, right? And a child still right now in the US, a child is under federal law still under 13. But we're seeing various state laws define a child as under 16 or under 17. There are some ongoing proposals that are looking at under 18. Sarah, I know your organization is submitting comments on other laws and proposals. I'd love to get your thoughts on what that landscape looks like, where we are on what is a child. I call them teens. My team hates that I say that because of children and teens. But what we keep talking about, minors, children, teens, kids. I don't even know what to call them anymore.
Yeah, I think this is one of the hardest things, because there's no way to categorize where a individual is developmentally based generically on age. So, but we do know that 3-year-olds are very different than 17-year-olds. So how should we be treating those people differently? And they are people. 3-year-olds are people. 17-year-olds are people. So how are we making sure that their privacy is protected in a meaningful way and individuals have the agency that is needed relative to their development? I think that this is going to be a discussion that policymakers are going to be having, not just this year, but for years to come. What is a kid? What is a teen? Who can make the decisions on how things can happen? And where should they have agency? But I think a lot of the conversations right now, especially at the state level, are revolving around content and where are kids and when can they access content. COPPA is not a content law. But we're seeing a lot of discussions at the state level. And I didn't think if I would have guessed 10 years ago or more than 10 years ago when I got into this policy area that I would be talking about porn as a policy item.
Right.
I didn't think it would be, I didn't anticipate it, but there's a lot of proposals in figuring out how to make sure people under the age of 18 are not accessing pornography on the internet. And how there's that threshold, but then there's the threshold of, are kids accessing harmful content? Those sort of discussions are happening. And then we get into speech issues, generally First Amendment issues, whereas COPPA, we're talking about the data collected from a child and not what they're accessing. So I think it's a difficult question that we're talking about, because a lot of the conversations are conflated between privacy, access to content, access to kid safety. I think I'll throw out the very commonly used phrase, it depends. And we're going to have to look at this. It may not be that we can make a holistic statement of what is a kid, because it depends on which area we're talking about.
Right. And I think the conflation that you're talking about is this shifting paradigm between actual knowledge and likely to be accessed by a child.
Mm-hmm.
Right.
Yep.
And that likely to be accessed by a child, as you said, leaves things wide open, such as a child needing to read the New York Times to do research for a project. Right. So is the New York Times now something, a platform, a website that is directed to children? Those are the types of questions that we're faced with, right? And once you determine content and where you fall on that paradigm on content, on age, then you got to figure out how you're dealing with the privacy and the data, right? So it becomes so conflated. Go ahead, Rukiya.
When you talk about content and when you talk about that, I just thought about another one of the proposed changes, how it's tangentially related. And that would be where the FTC was considering engagement techniques in connection with personalization and promoting engagement. And I thought about when you talked about porn, Sarah, I was thinking about sometimes in machine learning models, there are instances where the collection of persistent identifiers is used to filter that out.
You're right. And the FTC even says that in their FAQs, like when somebody is going through the sign up process, making sure you're dropping a cookie if the kid says they're under the age of 13. How do we make sure that we are serving kids the right content that they should be seeing online, and that kids still can access the information that they should be able to see online? Like, we can't, things never go well when you put a strict limitation and say kids can't do this.
That's an invitation for them to do it.
No faster way
right.
for a kid to get access to something. No, you
right.
can't have ice cream.
Right.
Well, ice cream is the next thing that's happening.
Exactly. So, Sarah, I want to take advantage of your expertise in a certain space that definitely overlaps, and it's been something that the COPPA rule touches on and has touched on over the years in many ways. I think this amended rule goes further than we've seen in the past, which is COPPA in schools, right? So I'd love for you to talk just briefly about COPPA, FERPA, and what you're seeing with regards to the schools and the changes to the amended rule.
Sure. So just some level setting here. In the schools in the U.S., we have the Family Educational Rights and Privacy Act, or FERPA. When the FTC began the rule review, and before that, they held a couple workshops on COPPA in the schools, and worked with the Department of Education on one of those workshops to talk more about how COPPA should be thought about in the context of educational technology or technologies used in the classroom for classroom purposes, not general consumer technologies, generally speaking, but those that are used aligned with the regulations in FERPA, what that looks like. And there's always been confusion about how to make FERPA and COPPA work together. So the FTC in this rulemaking is trying to better clarify how COPPA can work in the schools by providing some guidance on school authorized purposes and giving the schools the ability to provide consent. It doesn't take the obligations away from the vendors, but it gives them the ability to recognize that the schools can provide consent in limited circumstances. They can't just provide consent to operators for everything under the sun. It has to be related to an education purpose. And vendors can only use the data for limited purposes, which the FTC is looking for feedback on. So this is intending to clarify how schools can provide consent to vendors and how vendors need to provide notice to schools and also to parents on their website when they are providing services to schools under this school authorization.
I mean, I think that with guidance both under FERPA and COPPA, at least it creates hopefully a bit of a level playing field, only because every school operates differently, right? I mean, on district level, county level, state level, no two schools are operating the same with regards to how this is working, right?
And that's how our education system was set up in the U.S.
Right.
It is a bipartisan, multi-partisan, nonpartisan agreement that the decisions for education are better handled at a local level. So you're right that districts or even individual schools, when you're talking about private independent schools, are setting up their own privacy practices. Some of them are more robust. Some of them are aligned to the desires of the the educational community. But I think that FERPA itself was intended to be a floor for privacy protections. So that's why you've seen a number of states introducing laws that protect student privacy at the state level.
Right. And I think for us as a safe harbor, when we work with developers who are putting their products in schools, part of our conversations with them is ensuring that whatever they're doing, that it's transparent no matter who is getting that consent, right? And that it's very clear, and that they have that they understand that for one school it may be the teacher, for another school it may be the parent, but that you have to write this in such a manner that is very clear and transparent. And I think that one of the challenges that we still see across the board is notice, and how to make notice transparent, to not bury things in a privacy policy. I think there's some changes in the amended rule about that. We could talk about that briefly.
Oh, sure. I mean, we're just talking about where to put it, Donna, so that it's not buried. I know that you and our team had the brilliant idea to put it in a pop-out notice where we're already looking at that initial state of assurances, the policies and procedures. Just put it right there so that it's not buried somewhere at the end. It's not buried somewhere at another point in the process. So I know that would be our recommendation in our comments, to utilize technology and use the pop-out notice. So it's right there. Everything is right there so you can see it. And I as a parent agree with that too.
And I think there's something to be said for short form, if we're talking about privacy policies, right? Short form privacy policies that, look, I think what consumers want to know is what information you're collecting, who you're sharing it with, and the why, right? The why is what connects the dots. The example I often use there is you download a flashlight app, and you open up the flashlight app and it says they want access to your contacts. Like, why would a flashlight app need access to my contacts? Well, maybe this particular flashlight app has some sort of emergency thing in it that allows you, if something happens to you, that you can contact one of your contacts. So explaining the why in that scenario would explain, okay, this is why they need my contacts. And also providing the upfront ability to opt out of whatever it is you need to opt out of, right? But trying to find ways to do this in a way that is just in time, upfront, not buried anywhere, doesn't really interfere with the UX, with the user experience, so that they're taken somewhere and can't find their way back to where they wanted to be originally, what they're trying to get at. And I think that I would encourage companies to get creative about this. I think there's so many creative ways that we're just not seeing because people are so concerned about the law and the rule and working in this very small box and not understanding that there's actually a larger toolbox here to work within, and to do some really great, I think, design and implementation on consent and notice. And I'm not seeing it as much as I wish I was seeing it.
And Donna, I know that a lot of times when the attorneys are from CARU are assigned to a safe harbor, that's one of the things that they talk about upfront. And a lot of times the creative teams are on those initial calls so that we understand what it is that you're trying to do and just ensure you're complying with the law. So if you want to incorporate this creative element, if you want to use this toggle, what is it that you want to do? And I think that that's another benefit of having a safe harbor. Instead of just doing A, B, C and being very, we're able to help people do things creatively in a way that is consistent with the brand, with the look, with the feel, and promotes and user experience. It's not a distraction. So I do think that is a benefit when you're talking to companies overall of having a safe harbor. We're able to help you do those things and work with those teams.
I mean, and I think that, there's been some parameters around privacy policies and, making them look very plain and easy to read, and there's no animation. But I think sometimes you think about the audience, and, whether or not animation actually can help convey some messages, using video as opposed to just reading text, right? Having a character in a game explain what this all means. I think there are just so many different ways to do this. And I think we continue to encourage companies to go down that path. So as I talk about characters, Sarah, one thing that we had talked about when we were prepping for this was avatars. I'd love to get in the conversation of avatars and specifically what the FTC is looking at with regards to what constitutes personal information. We internally at KBU were talking about whether or not your username on a platform is considered personally identifiable information, because what I have said is that I think it can be, because what we're seeing is that children, minors under 18, those under 13 who are on these forget about whether or not children under 13 are supposed to be on these platforms. That's a whole other separate issue. That's a separate podcast. But let's just assume that everyone who's on these platforms, regardless of age, they're creating identities and they're starting to create brands, their own brand identity for themselves, and using the same username on every platform that they create a presence. And does that identify, is that personal information? And I think the same question goes to avatars. So I'll turn to you to really talk about the complications there and the issue.
Yeah, so the FTC had a pretty specific question about whether or not an avatar generated from a child's image would constitute personal information under the COPPA rule, even if the photograph of the child itself is not uploaded to the site. So they're, I think, thinking about if you take your phone and it generates something, that's what I think they're thinking about. I don't think they're thinking about like the penguins in Club Penguin or other kids directed, or your little creatures, whether it's a penguin or a kitty or a whatever. Are those personal information, or is the like something that will show that I am wearing a blue shirt and something else? Is that personal information? I think that's going to be a really interesting discussion, because I think avatars like penguins and kitties allow you some sort of anonymous play on the internet, but still allow some sort of humanization. Funny to say in the context of penguins and cats, but also avatars generated from images, a kid's image that may look like the kid. Again, I don't know if they're actually going to look like the kid. If it's built with like colorful bricks or something like that, it may be different, but we'll see. I'm actually really interested to read those comments.
It would be so difficult to make such a blanket a rule in connection with avatars, because the metaverse is a place where you can be anybody. And we're seeing that as a place as escapism. So people can make this avatar be anybody, different tone, different hair, different everything. So you can be who you want to be, but there is technology that is amazing. Some of our national partners have technology where you can upload your picture and your avatar pretty much look just like you, Sarah.
Just like you. That's right.
It's amazing. You upload your picture and it will, down to the thin parts, the eye shape, the nostril shape even, and the lines on your face. So technology is amazing, and I know it's going to continue to get more amazing. And I know we don't want to do anything to stifle technology, but I think that proposing a blanket rule in connection with avatars would be so difficult to determine which companies are just penguins with a different color scarf, or using your photograph. So I think that would just be so different to incorporate. And for those small companies, it would just be, I think that would be very difficult to incorporate.
Well, yeah. And where do you draw the line? Because a lot of these places that allow the avatar creation allow customization. And so when does it become the penguin with the scarf versus something that looks exactly like me?
And who would know? And how would you know, even in that initial setup stage? Am I using this to set up myself, or someone who I aspire to be, or someone who's just fantastical in my mind? Yeah.
We've talked a lot about various revisions. I'm going to ask both of you, what are top of mind for, out of all the revisions that you've seen in the COPPA rule, which ones are top of mind for you?
The education authorization is obviously a very big thing for the community that I work with, but also I think broadly impactful in the education sector. I also think the direct notice requirements and changes are going to be something that companies are going to need to follow and work with going forward. And then I do think that the data security and data minimization pieces are going to be something that is not only going to be a focus of the likely new rule, but also a focus of the commission going forward in their cases.
And for me, it would be the requirements for safe harbors. As a safe harbor, that is top of mind for my team. And also for verifiable parental consent, just excited about the new proposed means. That's top of mind.
So I will echo that with regards to operating a safe harbor. The process for us moving forward is not going to be particularly easy or fun. Just so listeners understand, the process for safe harbors is that whenever the rule is amended like this, all of the safe harbors have to resubmit a full application to be certified again. So it's like starting from scratch. It's a bit arduous. It's necessary. I don't object to it at all. I've been calling for more oversight of safe harbors for many years, so I don't object to it. I think that the more transparency there is, the more validity it gives to and veracity it gives to safe harbors and to those companies who decide to spend their money on ensuring that they are doing the right thing. So I welcome it. It's just not a process I'm looking forward to, but we will get there. And I think, as we said at the top of today's conversation, there's nothing for companies to do today or tomorrow, but they need to be watching this closely, and they should go back and read the rule and again look at some of the changes we highlighted, especially those efforts that you can do today that you're going to have to do anyway, like data security, right? So looking at those types of things, and I think starting to investigate providers to help you with data security, providers to help you with verifiable parental consent, and how you do notice and choice better. There's nothing stopping companies from beginning to have those conversations now. But again, there's nothing to do today or tomorrow with regards to compliance with COPPA. So with that being said, I'm going to ask you both to look into the magic 8-ball that we used to shake and tell me where, in 2024, where are we with regards to us seeing a final COPPA rule? Is it 2024? And I'm going to toss in not just the rule, but are we going to see any kind of movement on a federal level, whether it's with COSA or the Children and Teens Online Privacy Protection Act, COPPA 2.0, or CTAPA? What does 2024 look like, ladies?
I'll start because I don't have too much to say, Don. I don't think it's happening in 2024.
None of it is happening? None of it?
Maybe it's just wishful thinking. This year is already passing by so quickly. I can't believe we're almost in second quarter. So my vote, I'm going to put all my chips on 2025.
Okay.
Well, the 2013, what finally came out in 2013 took a couple of years. And I think the FTC is invested in getting this right. So it may not be that we see this come out in 2024. And we don't know what's going to happen with the makeup of the FTC or who's going to be in the White House because it's a presidential election year. But I think everything that has happened at the Federal Trade Commission on kids' privacy has been relatively bipartisan and strongly supported by the entire commission. So I think that there is an interest in moving something forward that can be supported by all of the commissioners. So I believe that the work of the staff is going to be focused on getting out a rule that can hopefully work for 10 years, or at least reflective of current technology practices and the needs of the community. I think more broadly on a federal level, I wish we could all predict what's happening, but it seems like every week is Kids Privacy Week. We're also seeing states pass kids privacy laws. We saw Connecticut has one, Maryland is considering one right now, Minnesota is considering one, Florida, South Carolina, New York. So there can be there's a lot happening, but it may be that the COPPA rulemaking is the steady ship in all of it, and there's a lot of people that are invested in making sure what comes out is done well. So however long it takes, whether it's 6 months, 12 months, 2 years, there's a lot in this proposed rule, and a lot to respond to and a lot to think about. So it's going to take some time, but I have confidence that they'll do it right.
I agree with you completely. And I think what's interesting about this particular rulemaking process is the additional questions that were asked, right? So it's clear that there are still some unanswered questions for the FTC. That all being said, my prediction is December 2024. We see a final rule, or at least another. We're going to see something in December of 2024. It's either going to be the final rule, which is probably not likely, but another amended rule, because if they ask all these questions and they get answers, they're going to have to at least publish another rule for review by the public. So I think that December 2024, we're going to see something.
Whatever the last working day of the year is, exactly. Like yes. December 30th or something like that, it'll get published.
Sarah and Rukiya, thank you so much for today's conversation. I think this was it was a lot of fun. I think we touched on a lot of things with COPPA, and hopefully the audience finds it extremely helpful. I would encourage them to look at the resources that we put in as well. You can access the FTC's COPPA rule changes, get information about our COPPA safe harbor. So a lot of resources there.
Thanks for having us, Donna.
Thank you.
Thanks for listening to us today. As always, if you missed any of our previous episodes, you can check them out at accountabilitystudios.org, Apple Podcasts, Spotify, or wherever else you find your podcasts. Please be sure to leave us a review. Let us know what you'd like to hear on our next Privacy Abbreviated podcast. And please check out our resources related to today's episode. And thanks again for listening.